Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Stephen T. Northcutt, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everyone. Welcome to this remote session of the DCA. If you represent the appellant, you're entitled to reserve up to 5 minutes of your time for rebuttal. And if you will let me know at the start how much you would like, I will try to give you a heads up when we get there. Our first case is Otis versus Thoratec. We're still missing someone. There we go.
Good morning. Morgan Weinstein on behalf of the appellant. If I could, I'd like to request 5 minutes for rebuttal.
Sure thing.
May it please the court. This case is about jurisdiction, or at least at this stage, this case is about jurisdiction. The allegations are that Mr. Otis died because nobody told him of an urgent recall of a medical device that was implanted in his body. And nobody told him that, even though the defendants in this case are alleged to have known that Mr. Otis was in Florida at the time, had phone calls with Mr. Otis at the time, and heard Mr. Otis tell them that he was experiencing complications, including low blood flow. That was one of the complications at issue that prompted the recall of the device. Notwithstanding all of that, when he was having these telehealth visits with his physicians and with these defendants, he was not told about the issue. Instead, he was told that he was dehydrated. He wasn't told to go to the hospital the first time that he called. He was only eventually later even told to go to the hospital. He died from complications regarding the very device that was recalled. And the question on review is whether Mr. Otis, his estate, both in the complaint and through the affidavit that it filed in opposition to the motion to dismiss based on lack of jurisdiction, has sufficient facts to enable them to get to an evidentiary hearing on the matter, as is contemplated in Venetia Salami and Wendt. That evidentiary hearing would have entitled the estate to cross-examine the affiant for the hospital defendants in order to determine whether jurisdiction actually existed. It was supposed to be limited.
Can we reconcile the affidavits in this case, though? What's the dispute of fact that requires an evidentiary hearing?
The dispute of fact is that the affidavit that was provided by the estate states very clearly that there were telehealth visits that were occurring between the hospital defendants and Mr. Otis at the time that Mr. Otis was in Florida, that the hospital defendants were aware that Mr. Otis was in Florida at the time.
Has the hospital disputed that they were aware that they were aware of his location at the time at some point? I mean, I know there might be a dispute about which particular. Let me ask you this: is it one thing I could perceive of a dispute, not a dispute, but perhaps a question is, which of the telehealth appointments were conducted at a time the plaintiff was in Florida? And the reason that you tell me might be important is because, wouldn't it need to be the one at which the advice was given that was, tortious?
Well, so in both instances, in both of the telephone calls that occurred while he was in Florida and while they knew, the affidavit attests that he was never told of the recall. He was told that he was dehydrated.
So you're saying all the telehealth appointments were tortious, right?
Yes, Your Honor, because
so they're all tortious. So they're all tortious. We don't have to discern which ones included bad advice and which ones didn't. So is the hospital disputing that they knew that he was in Florida at the time of the telehealth meetings?
They are not disputing that they knew that he was in Florida.
What do you need an evidentiary hearing for?
We need an evidentiary hearing.
As opposed to just reconciling the affidavits and deciding it as a legal question.
So we have alleged both specific and general jurisdiction. The telehealth visits with Mr. Otis himself go to the facts of specific jurisdiction. But there is a question that needs to be resolved as to whether these were telehealth visits. Telehealth is a statutorily recognized service in Florida. And if there were telehealth visits with Mr. Otis while he was in the state of Florida, and those telehealth visits were in fact tortious, then if that's conceded, we wouldn't need to be here, but not because the hospital defendants should win, but rather because this matter should have been decided in Mr. Otis's estate's favor in the first place. Our position is that a limited evidentiary hearing is needed because there are facts which can't be reconciled. And those facts would include whether these were telehealth visits. If the hospital defendants concede they were telehealth visits, then no, we don't need a limited evidentiary hearing because we've established specific jurisdiction, and this court should reverse with instructions on remand that an answer should be filed rather than a limited evidentiary hearing should be conducted. So far as general jurisdiction goes, the hospital defendants have also stated that they were not at all involved in telehealth in the state of Florida. And so they have contested the notion that they were engaged in the provision of these services or the marketing of these services in Florida. And a limited evidentiary hearing would also elucidate the veracity of that contention. Because if in fact they were engaged generally, continuously in a marketed endeavor to gain Florida patients or patients who were in Florida at particular times to engage in telehealth with them, that would establish both the minimum contacts necessary under the jurisdiction statute as well as the general jurisdiction component. And so for both specific and general jurisdiction, it is our contention that a limited evidentiary hearing would be required under Venetian Salami and went. The affidavit that Mr. Otis's estate filed provides both residency and proof of the telemedicine consultations, asserts that he attended several telemedicine consultations with employees of New York Presbyterian Hospital, and that the hospital was aware that he was in Florida, and to the extent that the affidavit provided testimony regarding the operation and conduct of telemedicine services in Florida at the time of the tortious conduct, the affidavit goes to the heart of the jurisdictional question. It's in conflict with the hospister defendant's assertion that no such operation or conduct took place.
Mr. Weinstein, if Mr. Otis had called the hospitals from, let's say they happen to be in Singapore, let's say they happen to be in Washington State. So your position is wherever they were calling from, so long as the hospital knew about it, the hospital could have reasonably foreseen being hailed into court in that forum?
If the hospital knew where they were, well, let me say this. If Singapore or let's say Tennessee or any of the other places that we could be talking about had the same jurisdictional test as Florida, yes, if the tortious act occurred in that state, because the Florida statute provides that if the tortious act occurs in the state, that's where you go. And the Internet Solutions case that we cite states that that can simply occur through omissions in a telephone call. Here we have omissions in multiple telehealth visits. And so both under the statute regarding telehealth in Florida and under the Internet Solutions framework, yes, that would be sufficient to be hailed into court so long as the tortious act occurred in those phone calls. It's not simply that they knew that he was in Florida and they had a telephone call. For instance, if they had called him and stated, Mr. Otis, your bill is overdue, that would not be sufficient for them to think that they should be hailed into court.
Well, can't speak for Judge Rossignocum, but it is simply that for jurisdictional purposes. It's not simply that for the tort purposes, but it is simply that for the jurisdictional purposes, right? It's simply the fact that he is in Florida and the individuals providing telehealth care are aware of his location.
When traveling under general jurisdiction, them being aware that he was in Florida and him being in Florida would not be sufficient. When traveling under specific jurisdiction, them being aware that he was in Florida and him being in Florida would not be sufficient. However, when traveling under specific jurisdiction, them being aware that he was in Florida and then committing the omission that constitutes the tort in a telephone call with him while he was in Florida would be sufficient for jurisdictional purposes. Is our
But I don't know if that addresses Judge Rustin Newcomb's question, which is, I'll reductio ad absurdum argument, which is, he could be anywhere and then he could be sued in Singapore, to use her example. The New York Presbyterian could be sued in Singapore.
Yes, I believe that that's what our statutory scheme provides, Your Honor. I believe that my reading of our jurisdiction statutes is that if they are aware that he is in a particular place and they commit the tort on the phone with him while he is in that place, that is sufficient to establish jurisdiction under a specific jurisdiction analysis.
Well, where does the tort take place? The omission occurred in New York, right?
No, the omission occurred in Florida. Mr. Otis was in Florida at the time that he placed the phone call, the telehealth visits with the hospital, and the hospital defendants were aware that he was in Florida and directed him not to go to the hospital in Florida, and then directed him to go to the hospital in Florida, but did not tell him either time, is my understanding of the complaint and the affidavit, of the failure of the device.
So the statute requires an omission in Florida, an omission by the defendants outside the state if they were engaged in service activities within the state. So yes, you've got activity outside of the state and inside of the state, and you're saying that the same action covers both.
So
they said it outside of the state, but it was also inside the state. Is that correct?
They said it to him while he was inside the state, is our contention. If they said it to him while he was in New York, then they would both be in New York and it would be in New York. But they said it to him while he was in Florida, and they were aware of that. And they directed him as to what to do in Florida. They told him to go to a hospital in Florida.
Basically, by answering the phone, they subjected themselves to the jurisdiction of the state of Florida.
No, Your Honor. Because again, this is solely when we're talking about a specific jurisdiction analysis. The facts would obviously be much different under the general jurisdiction that we're alleging. But with regard to specific jurisdiction, it is not sufficient that they answered the phone. It is only sufficient that they answered the phone and committed the tort while on that phone call.
No, I think again, that was the point I was trying to make. That's a connexity issue. I mean, maybe I'm mixing apples and oranges with specific and general, but that is a connexity-like point you're making. We get it. They committed the tort on the phone. That's your theory. But the point is, for jurisdictional purposes, the only thing that that invokes specific jurisdiction is the fact that they knew when they answered the phone that he was probably calling from Florida or whatever. When the call connected, that it's probably from Florida. That's the only thing.
They knew that he was calling from Florida is the only allegation. Yeah, that's the only allegation with regard to the specific component of the jurisdictional analysis. I mean,
yes, thank you. That's what I meant. I'm gonna but go ahead. You can. I don't want to cut you off because you have a private counterpoint. Go ahead.
We also allege sufficient minimum contacts, and we go through the entire jurisdictional.
Well, can I before you get to that, can I go back to this? You said it in your brief, the Hunter case. I mean that's not I don't think that's just from Hunter, but just about in the contacts that are fortuitous, random, or isolated. I mean that phrase, that 3-word phrase, sort of applies to really the scenario, the aspect of jurisdiction we were just talking about too, right? Isn't it random, fortuitous? Maybe not isolated. Maybe there was a few calls, but it's still random or fortuitous. I mean, what if we had a home in Montauk? I mean, that's New York, sorry, or in Hilton Head too. It's just random where he calls from, right? Especially in the age of technology. I mean, he could call from his boat in international waters, right?
I think that could be true, Your Honor, except for the fact that our position with regard to Hunter and the reason that it is important as distinguishing West Wind Limousine versus Shorter is that the analysis in Hunter was that the defendant didn't know or intend for that type of activity to occur, whereas our position is that the hospital defendants were engaged in telehealth activities in Florida and in fact marketed those activities to a market in Florida such that it would be expected that those type of activities would occur.
Let's talk about that, Mr. Weinstein. Mr. Weinstein, let's talk about that for a minute, because I assume you're talking about this virtual urgent care exhibit that was attached that shows that 2 years after the incident, apparently the hospital or some section, some entity connected to the hospital defendant was engaged in virtual urgent care in Florida. That's all we have. We have an internet page. We have nothing suggesting that there was marketing. We have nothing explaining how the program works or when it was instituted. And I think even if it was in effect at the time of the asserted injury, but even if it were, I think, isn't that where the connexity issue comes up? Because Mrs. Otis at no time in her affidavit alleged that they were going through this virtual urgent care program, that they had any knowledge of this program, that it had any relationship whatsoever to them calling the New York hospital where their New York surgery had been performed because they were New York residents. So isn't that where a connexity problem arises? Even if we were to look at that webpage in the light most favorable to your client and say, yes, that shows some degree of activity in Florida that raises a question?
If the activity in Florida is sufficiently continuous and ongoing, Your Honor, then there would be no connexity problem there, particularly because it's directed specifically to Florida. And so viewing that in the light most favorable to my client, I believe that it would resolve the connexity issue rather than present it. If they were engaged generally in marketing and providing telehealth in Florida, pursuant to the Florida statute on the issue, I think that would be sufficient to resolve the connexity issue. And I think that your Honor is correct that, I mean, yeah, it would have been better if it was from a time before the occurrence of the event.
And Mr. Weinstein, you are right at your 5 minutes left, so use them as you please.
If it's okay with the court, I'll finish this answer and then reserve the rest for rebuttal. And I think that the limited evidentiary hearing that we are saying should have occurred, and that I think that the case law also says should have occurred, could help to resolve the extent and nature of those telehealth services that were being provided, because we would be able to cross-examine the affiant for the opposing side. With that, I would reserve the rest of my time for rebuttal unless the court has any more questions for me now.
Sure thing.
May it please the court, Dinah Stein on behalf of the hospital defendants, and we contend the trial court was eminently correct in holding as a matter of law that this New York hospital that treated this New York resident in New York did not subject itself to the jurisdiction of this state by answering some phone calls regarding this continuation of his care that originated in New York. Now, before I'm going to address, I think, first of all, this inquiry, before I address the whole issue with the evidence and the evidentiary hearing, could start and stop with the complaint, because that's the first step of any personal jurisdiction analysis, is you look to the complaint to see if it even alleged specific or general jurisdiction. And this complaint mentions Florida once and says very vaguely that the hospital conducted telehealth consultations and appointments with patients located in Florida. That is neither specific to this case regarding the connexity required for specific jurisdiction, and it does not allege any substantial and not isolated contacts that are necessary for general jurisdiction, let alone for constitutional due process. So we have that already fatal problem with plaintiff's allegations of personal jurisdiction. Now, when we get to the evidence, I want to make clear their affidavits were submitted. There was no conflict in the affidavits. The defense counsel started the hearing by saying the evidence on this issue is not disputed. There was no objection from plaintiff. Plaintiff did not object to the way the proceeding was conducted. Her counsel did not contend that it needed to be involved testimony. No testimony was proffered. The plaintiff's counsel was very satisfied with the way the hearing was conducted. Now, as far as the affidavits, and I'll make another point clear because plaintiff now talks about general jurisdiction. In response to the motion to dismiss, plaintiff did not allege general jurisdiction. She cited the statute for specific jurisdiction and the 3 separate components, but never said that there were substantial and not isolated contacts with Florida. So we submit that point is waived for purposes of this appeal. But as far as the evidence itself and the connexity, and I'd submit, you know, Judge Moe really honed in on the same question that Judge Rothstein-Yoakum stated, and that is, and she said to plaintiff's counsel, I'm trying to understand your argument. You're saying you as a professional, just like a doctor, if Mrs. Otis called you from Nevada and asked you about this case and you gave her advice, would you be subjecting yourself to the jurisdiction of Nevada for personal jurisdiction purposes? And plaintiff's counsel had a very difficult time answering that because the answer was yes. He conceded that was potentially an issue. And, you know, that is the issue, is that these were calls that were made from someone who was vacationing in Florida. As far as just one other point to make as far as these telehealth services, and it's absolutely correct that the only evidence of telehealth had nothing to do with Mr. Otis. It had nothing to do with the time frame of when everything occurred. It was hearsay. And the plaintiffs now are talking about the telehealth statute in Florida. That was raised for the first time in plaintiff's reply brief. It was never raised below. It was not raised in the initial brief. I just say this to point that out to the court. I don't think it adds anything to this conversation or this discussion because it is not a jurisdictional statute. It does not subject healthcare providers to jurisdiction. I just wanted to point that out to the court to the extent there was some discussion about the telehealth statute. That too is waived, we submit, for purposes of jurisdiction. As far as the alleged issue of awareness, plaintiff hasn't cited to a single case that says if you accept a call from another state and you're aware the person's in the other state, that subjects the defendant to jurisdiction. I'd submit, in fact, this court has already answered that question quite clearly in the Robinson helicopter case a few years ago and said, you know, even answering calls and sending things to Florida when it's not directed at Florida and the defendant's just responding is not sufficient. So, you know, even if we decided there was a fact issue on awareness, which there absolutely isn't, we just contended it was totally irrelevant, there'd be no reason for a evidentiary hearing. And of course, there'd be no basis for finding personal jurisdiction. If we can get beyond the undisputed evidence and the complaint, it is also very clear that even if somehow specific jurisdiction was established, and it was not, somehow general jurisdiction was pled and argued and established, which it was not, we still fundamentally lack minimum contacts for constitutional due process purposes. And you know, again, that's really, if there had to be a nail in the coffin, it would be due process, because these are hospitals, which we made clear in the affidavits, which were not disputed, don't do business in Florida. They don't reach out to patients in Florida. To the extent there was a web page that was created during COVID, perhaps, which was no longer even up at the time of the hearing, that assisted their own patients with medicine, there was absolutely no evidence in this record that the hospitals direct any type of services to Florida residents. And so without that in the record, and frankly, it would never be established in the record, the plaintiffs just can't get to the final requirement to be able to hail this New York hospital into a Florida court. So again, just to repeat, jurisdiction was never pled. constitutional due process was never pled. There was no dispute in the evidence. The evidence was clear from this court's well-established law, from law all over Florida, from other states, that this was not the type of activity that would allow a defendant, particularly a hospital, to be hailed into a Florida court. And in any event, plaintiff can never establish minimum contacts. So we would ask the court to affirm Judge Moe's finding that this is not even a close case, and allow the dismissal to stand. Thank you, Your Honors.
Thank you, Ms. Stein. Okay, Mr. Weinstein.
Yes, Ms. Stein has stated that she believes that the complaint is insufficient in its allegations of jurisdiction. We believe that not to be the case. The statement that they were involved in telehealth services in general meets both the minimum contacts that we are talking about and also could be leveraged in terms of general jurisdiction. What's more, the complaint alleges that they were engaged in those telehealth kind of services with Mr. Otis at the time of his death. Ms. Stein states that the response does not state that the activity was substantial or not isolated. We believe that the entire time we've been stating that the activity was substantial and not isolated, and that the screenshot of the website or the link to the website at the time demonstrating the marketed services would also point toward that. Ms. Stein states that the telehealth statute was referenced for the first time in the reply brief. We don't dispute that. We've always discussed telehealth, and we are not using the telehealth statute as a mechanism to provide jurisdiction. It's simply that telehealth is a regulated kind of transaction in the state of Florida. We believe that the facts are sufficient to have entitled the parties to an evidentiary hearing, the limited evidentiary hearing that's required under Venetian Salami, that's required under Wendt. We also believe that, per the Capilla decision of this court, which we cite in response to the attempt to leverage Stonepeak, there need be no local office, there need be no local agent, there need be no lease, there need be no meeting, and there need be no presence of corporate officers. What the court said in Capilla when talking about Stonepeak, which is, one of the cases that would provide for a rigid set of factors for us to be able to get into this court based on the provision of medical services or, services like medical services, is that the activities at issue in that case concerned a business transaction that was sought after but not consummated. That's directly opposed to what happened here, where the estate says the services were sought after, and the defendants told the decedent that he was dehydrated, and then told him eventually to go to the hospital. But there's no allegation in the complaint that they actually told him that he needed to have his device removed, and there's no allegation in the affidavit that they actually told him that he needed to have his device removed. He died because of complications with the device when he was talking to the hospital defendants from Florida about what to do, and they committed an omission where they didn't tell him that his device was malfunctioning and had been urgently recalled. They could have just told him it had been urgently recalled. And with that, we would request that the court reverse the decision of the trial court and remand for the hearing that we've requested, which is the limited evidentiary hearing that we believe is required under the case law. Thank you.
Thank you, Mr. Weinstein. Thank you both very much. In order to leave our virtual courtroom, you need to click the leave icon in the lower right-hand corner of the Zoom screen, and then you will be off into the ether.
Thank you very much.
Thank you. Okay, our next case is Raynon versus Oregon.
Good morning, Your Honors.
How are you, Mr. Lee?
I'm good, Judge. I'd like to reserve 3 minutes for rebuttal if I could, Judge. May it please the court. My name is Brian Lee. I am here representing Marilyn Raynone in this appeal. This appeal comes to the court from a denial of a motion for new trial, and we're dealing with two distinct issues in this case. One, comments by a defense counsel in closing argument regarding his client paying personally for either medical care or future medical care that was being asked for by the plaintiff, as well as a comment from a witness that the defense called, that was Dr. Weber, where he said that it would be horrifying if someone were to a doctor, one of Ms. Raynone's doctors, perform a future treatment procedure and would be malpractice in doing so. And so we have set forth in our brief those two issues for the court's consideration, and believe that individually, each individually should cause this court to reverse for a new trial, and certainly collectively means that a new trial should be warranted. So I wanted to start with the comments by defense counsel in closing regarding his client and medical bills of future medical care. Those are at page 8 of my initial brief.
I have a question. So let's
yes,
say
Honor, go ahead.
Let's say there was a perhaps simpler scenario where the tort had caused a wound, and the treating doctor was asked, this wound might become gangrenous and require amputation of a limb in the future, and the doctor said, "Oh no, that's not possible. Actually, the infection is going to be controlled, and to cut off his limb would be malpractice."
Right, and
wouldn't that just be tantamount to saying that, opining about what future medical care would or wouldn't be required?
I think everything in Your Honor's, what you said, the witness is going to say everything's fine until you get to malpractice.
Just mentioning it's a talismanic word,
as opposed to saying a doctor committed malpractice.
I think both, Judge. I think we're.
What if he said no doctor would ever cut off this leg because it's never going to get gangrenous, and any doctor who did would be falling below the standards in the community for medical care?
Sure.
Is that close enough to the talismanic word malpractice to get you a new trial?
Sure. Frankly, Judge, I would be arguing that it is. I mean, I guess there would be, if something were, if we were talking about standard of care, right? That sort of harkens me to a medical malpractice case, right? So like if a doctor, if you're in a medical malpractice case and one doctor says, I believe that was below the standard of care for a doctor to do that, right? It's not saying that it's malpractice, but you're in the context that you're in that kind of case, doctors can say that you fell below the standard of care.
But isn't it just another way whether you say malpractice or you just say no doctor would ever do this, isn't just another way of eliciting honestly defense-friendly testimony out of a plaintiff's witness that no, this care is not ever going to be needed?
Well, I don't think it's the same thing, Judge, because we have, which we talked about, we have specific instructions or a specific instruction regarding situations like malpractice, right? Where a defense, where the defense could make a claim for that some doctor committed malpractice, and it's very clear with the instruction and with the case law from Stewart v. Hertz and on that is not a defense that the defense can make, meaning that the defense is still, even if there is malpractice, even if everyone agrees that there's malpractice, that is not something that they can bring up to the jury to cut off their liability for damages. And so when we're talking about having testimony.
But what you're saying then is that if there's no chance that the leg would turn gangrenous, you're saying, well, if a doctor happened to be just wildly out of his depth and cut off a leg anyway, it's still, the causation's there. There was a fender bender, he hurt his leg, it wasn't gangrenous. But is that what you're saying?
Yes, I think that's the actual instruction. The Stewart versus Hertz instruction that normally is given in those situations is even if there is clear malpractice, by a doctor, there's an instruction that says the jury can find that
isn't that that's past malpractice? That's past malpractice. This is saying some. Is there any case? Do you have any case that says, phrasing, testimony phrased in the future, saying, this type of care would never be undertaken because it would be malpractice to do so in the future?
I don't think. Yeah. I think that I'm looking through the cases that I have. Most of the cases, as court, I think, alluded to, does talk about sort of the past, right? Things that have already been done. Now there are cases where, I'm looking at this Nason versus Shafransky case. But it's talking about surgery should have been the last option, and he would not have recommended the surgery. Now that still is a past surgery, but the case law does not differentiate between and say, there isn't a body of case law that says that this is only to be used right in past situations where malpractice, using the term malpractice, is bad. Just in past situations, not in future, because I think that the underlying reason why it is bad, why it is improper, is because it is, number one doctor talking about another doctor, which is improper just under Florida law. You can't do that, or the care that is being done. And another two is when using the term malpractice, again, the case law does talk about that being sort of what you were talking about, sort of a bellwether term, that is something that is beyond the scope of what, because it's really meant to garner sympathy, I believe. And it's not, Dr. Weber just didn't say that part. Dr. Weber also threw in right at the beginning of that answer that it would be horrifying if Miss Raynone's treating physician performed a future surgery. Future medical care, as the court knows, was a big element of Miss Raynone's case. It was hundreds of thousands of dollars that were being sought for that. And so that comment went directly towards that claim. And so we believe that it was improper, not just because of the comments themselves, but because the jury was in a position where they had to determine that. And ultimately, they gave $0 for that.
Let me ask you a question.
Yes, Your Honor.
About, we are here on an appeal, not from the final judgment, but from the order denying a motion for new trial, correct?
I think it's both, Your Honor. I think there was a final judgment that was entered.
Well, there was a final judgment entered, but you seem to be challenging the court's denial of your motion for new trial.
Oh, correct, Judge. I mean, that was part of the trial judges.
So the question I have is, in this situation, you have what arguably is just a debatable question of whether the answer was really all that improper, but there was a curative instruction given, correct?
There was, Judge.
There was no objection to the curative instruction, the content of the instruction.
Correct, Judge. There was not to the form.
And the judge who sat in the trial and gave the curative instruction denied the motion for rehearing. Don't we have to give deference to the judge's ability to know whether or to what extent this incident was harmful? And don't we especially have to do that when we don't have a transcript of the trial?
I think, Your Honor, that yes, certainly the standard review is that there is this deference that is given to a trial judge.
Abuse of discretion, and we would have to conclude that no judge would have denied your motion for new trial. And I'm saying, how do we do that if we can't read the trial?
That's correct, Judge. But I believe that what you can do is there are things. I don't believe that the whole trial is necessary for this particular the transcript of the trial, but I can see the court, what you're saying, and my argument to that is that there are certain things that when they're said during a trial and objected to, the case law talks about that being just not fundamentally improper, meaning there was no objection, just improper, right? And so the court would have to determine that no trial judge would have done that in that particular instance regarding that. I do agree with you. I believe that this court should do that. But so hopefully that's answered your question. I do, though, want to go.
What is the trial judge's job on the motion for new trial? Is it just whether there was an error that occurred, or was there an error that deprived you of a fair trial? Isn't that what is?
You're correct, Judge. The second, it would have to deprive the plaintiff, in this case, of a fair trial. That's the error. I would say, if when a trial judge is looking at these things, there was two errors in this case. There were, so there is a certainly the individual analysis that trial judges, and certainly this court does, but there's also cumulative analysis that occurs when you're talking about multiple errors in the case.
We're talking about, you've raised two, correct?
That's correct, Judge.
And how many days was this trial?
It was a 4-day trial. But I believe that when we then add in, and even individually, look at the error that was done by counsel's comments in closing statement, that in and of itself is error that does not, because there is no doubt under Florida law that, and it's uniform, that any instance where a party talks about or infers the wealth or poverty of a party or tries to curry sympathy for the party with comments is improper fundamentally. And when you're talking about a comment in this case that is done where, and I'm looking at the record 1565, where defense counsel says, my client is not willing to pay for lifelong care for the scoliosis and syrinx, the Kyrie.
He didn't say his client was financially incapable of doing that, correct?
That's correct, Judge. But that's a distinction. And I would argue, Judge, that's the distinction without difference.
I think there is a big difference between willing to and able to.
I don't believe that is. I don't believe that the difference that you're seeing, Judge, or I don't agree with it, just because when you say my client is not willing to pay, what does that convey to a jury? That not only is your client unwilling to pay, but that your client's paying it. That my client, meaning the individual, is paying it.
But Mr. Lee?
Yes,
the jury made it very clear that they didn't care, right? Because even though your client was only willing to pay $18,000, or I'm sorry, even though the not your client, but the testimony was that he was only willing to pay $18,000, the jury awarded all the past damages that your client requested, right? The $138,000. So obviously,
past medical
the jury didn't really care what he Mr. Organ was willing or not willing to pay.
Well, I would disagree in the sense that the comment goes specifically. There are two comments, as the court says. One is that what they're willing to pay, that what his client, Mr. Organ, was willing to pay. But the first comment of that was that Mr. Organ is not willing to pay for lifelong care. That's future medical expenses. We know that the jury gave $0 for future medical expenses. And so when we're looking at whether this comment could have contributed to the verdict, that is there.
But again,
yes, Your Honor.
We don't know what all the evidence was in the trial. We don't know, my sense is that her need for future medical and whether she had a permanent injury was hotly contested, but we don't have that transcript. And the judge who considered your motion for a new trial was at that trial, correct?
That's correct, Judge. But when we're talking about the need for a transcript, that I believe comes into when there's an error that has been done. We think there was. Then the burden shifts to the other side.
But see, you're not complaining that there was an error that caused the final judgment. You're complaining in these briefs, as I read them, that the judge abused discretion by failing to grant a new trial because of this asserted error.
Right. I think yes, we're saying that, well, we're saying two things. We're saying that the judge failed to grant a mistrial, which we believe was error at the trial, and that later on, after the trial, the judge failed to grant a new trial based upon that, right? So they're two different things there. I think they're the same vein, right? I mean, in two different instances, the judge denied, he denied a mistrial at the trial when we believe he should have. He denied a motion for new trial when we believe he should have granted a new trial. And so once the, case law is very clear, special case, and the ones that I've cited to is very clear that if we show an error, which we believe we have, then it shifts to the beneficiary of that error to then show that it was harmless in some way. And we do not believe that the appellee has done that in this case.
But everyone, it's the appellant's responsibility in all of my years doing appellate work, it's the appellant's responsibility to show entitlement to relief on the record. And that goes beyond just showing an error, correct? It shows that you must demonstrate to the court that you have suffered a harmful error.
That's correct. I would agree with that, Judge. And I believe we have by showing that the jury did not award future medical expenses, and for one, didn't say permanency, didn't. Now, I certainly see the court's argument is that, look, this was a hotly contested case, and I don't
as far as I can tell, because I don't have a transcript.
Right, but both sides have agreed to that in their briefing. Both sides have said that there was evidence that it was hotly contested as to causation and permanency and even future medical expenses. You could see that from the transcript we have. But that, I believe, Your Honor, that proves my point. Just because a case is hotly contested does not mean that this error then now becomes harmless. I believe that when you have a case that's so hotly contested, any kind of error, especially this kind of error, carries even more weight with a jury.
You are down to your 3 minutes, Mr.
Oh, I'm sorry, Your Honor. I wasn't looking. I'll reserve.
Oh, don't apologize. You're entitled to use your time as you wish.
Thank you, Your Honor.
Mr. Spinner.
May it please the court, Sam Spinner with Carlton Fields on behalf of the appellee Joshua Organ. And this court should affirm the final judgment because Raynone has not met her burden to show that the trial court abused its broad discretion in denying her motion for new trial. And before turning to the merits, as Judge Northcutt noted, this court should affirm on the preliminary reason that the record is simply inadequate to show reversible error, especially viewed through the lens of the trial court's discretion and superior vantage point having sat through this trial. Raynone's given the court only a couple
and that discretion would apply during the trial at the time of an objection and a motion for mistrial and on the motion for new trial, correct?
Certainly, Judge. And without the full contextual backdrop in the transcript to review, the court simply cannot perform its reviewing function and determine whether either of the challenge comments were sufficiently prejudicial to vitiate the entire trial. And one thing that hasn't come up is why we don't have a transcript, which hasn't been answered. We know the transcript was transcribed because we have portions of it. It seems that Raynone simply chose not to obtain it and to provide it to the court for reasons that remain unclear. And as I say, this court has held that it must review the comments within the context of the entire trial. And in fact, the same exact comments can warrant relief in one case, but not another case, depending on the factual context in which those comments are uttered. Neither issue on appeal concerns comments so facially egregious as to strip the trial court of its broad discretion without a proper record to review. On the merits on the first issue regarding the closing argument, the trial court certainly did not abuse its discretion because the challenge comments were based on the evidence. These were not improper remarks on a party's wealth. They were not intended to invoke sympathy. And while we don't have the transcript to review, we know from filings that our expert agreed that Raynone received some treatment that was causally related to the accident. Our economist determined that that treatment was worth $18,000. And in candor to the jury, defense counsel conceded that this $18,000 was causally related. But based on expert testimony, the other treatment she received was not. And counsel today read the end of the argument where defense counsel said my client's willing to pay the $18,000. But what preceded that is important for the context, because what defense counsel said is that we're telling you we're fine with those allocation of damages, but you have to take liability into consideration. We're not admitting liability by saying we're willing to pay these damages, but if you come to a scenario that you're putting liability on my client, if you go to the next step for the damages, those are the damages we believe plaintiff would be entitled to. And that's a proper comment on the evidence. Defense counsel didn't say that Mr. Organ could not afford to pay more in damages. He didn't say, look at this poor young man, don't ruin his life with a large award. And in that respect, the court should contrast these comments with those at issue in the Cascanet versus Allen case that both parties cited, where defense counsel argued that there was no need to burden his client with an award and whether it was fair that she be burdened. And so that's really the difference in this case, is talking about burdens and fairness is sympathy. Talking about, based on the expert testimony, our experts, we have to concede that $18,000 was causally related to the accident, but that there's no future care, no permanency, is a stark contrast to the type of comments that courts have found sufficient as reversible error, even when they had the entire transcript to review, which we don't have here. I'll also briefly touch on the second issue. Dr. Weber's isolated statement regarding malpractice is not sufficient to warrant a new trial, especially because it was addressed by an appropriate curative instruction. I believe it was Judge Atkinson noted that they don't challenge the sufficiency of the curative instruction itself. The judge offered to give the instruction, and this isn't a case that fits under the Dungan versus Ford line of authorities, because this isn't a strategy to try to shift liability by blaming a treating physician for causing malpractice. It's really, as Judge Atkinson said, a talismanic word. And we're arguing about whether he could have used different language to say the same thing. He was emphatic. He apparently felt very strongly about his opinion. But this doesn't fit into the line of authorities that are essentially jury instruction cases, saying that if you're going to blame a treater for malpractice, that has to be accompanied by an appropriate jury instruction. And that's really a theme in this case, Your Honors, is that Raynone takes issue not with the substance of what was said, but the specific language that counsel or Dr. Weber used in expressing what is otherwise proper commentary and proper opinion. And so both issues on appeal are within the trial court's discretion. That discretion is abused when the ruling is arbitrary or fanciful, one that no reasonable person could possibly support. Raynone has not met her burden to show an abuse here, especially without a proper record to review. And these are not the type of issues that on their face, without that record, are so prejudicial to vitiate an entire 4-day trial in which there was 8 experts and 13 witnesses that the jury heard. And so for these reasons, unless the court has any further questions, Oregon respectfully requests that this court affirm the final judgment and the order denying the motion for new trial in all respects.
Thank you, Mr. Spinner. Mr. Lee?
Yes, Your Honor. So as I was listening to counsel, I'm formulating the arguments that I would do. The arguments that I would be giving is the exact same arguments I already have, frankly, Judge, as well as in my brief. So just for the court, in deference to the court's time, I would rely upon the arguments I've already made, as well as the ones in the initial brief, and would ask the court to reverse for a new trial in this case.
Oops. Okay. Thank you, Mr. Lee. Thank you both very much. In order to leave our virtual courtroom, you need to click on the icon in the lower right-hand corner of your Zoom screen.
Yes, sir.
All right. Our last case today is First Acceptance Insurance versus Same-Day Windshields. Okay, Mr. Clancy, you're up.
Good morning. May it please the court. I'm Joe Clancy and I represent First Acceptance Insurance Company in this appeal. I'd like to reserve 5 minutes of my time for a rebuttal.
Sure thing.
All right. There are just a few undisputed facts that I believe will resolve about 90% of the issues on appeal. Same day replaced the windshield of First Acceptance's insured and submitted an invoice. First Acceptance paid less than the invoice amount and same day filed suit. The policy contains an appraisal clause. The key sentence is, if we cannot agree with you on the amount of a loss, then we or you may demand an appraisal of the loss. Now, that's the same sentence that was in prior appellate cases involving appraisals of windshield claims, Progressive versus Hillsborough Insurance Recovery. I'll call it the HERC case, HARC, Progressive versus Glassmedics, both from the second DCA, and NCI versus Progressive from the fifth DCA. There are others as well, but those are the three main ones that I'll probably be referring to. The policy also has the legal action against us clause, stating that there can be no legal action until there has been full compliance with the policy. Now,
even under second DCA case law, well, even the other districts, is enforceability something that the trial court must determine before granting a motion to compel appraisal? Enforceability of the agreement? Doesn't the existence of an enforceable agreement have to be determined by a trial court before ordering appraisal?
I'm not sure what Your Honor means by enforceable. I've heard the term valid agreement. There's a valid contract.
Well, I mean, no, I didn't mean to create an invisible elephant in the room, but the elephant is the unconscionability, the declaratory judgment, one of the claims. I mean, yes, many of the claims, I'm understanding your argument to mean many of the claims are just, are just about the amount, did you just properly? And that's something, conceding your argument for the sake of this present discussion, could be seen as prematurely determining an amount that should be determined by appraiser. But is the unconscionability declaratory judgment count something that needs to be determined by the court prior to ordering appraisal? Because if it is unconscionable, then you don't have a valid agreement or an enforceable agreement.
Yes, that may be correct, but the unconscionability count, that was number 10 on their list in their amended complaint, that was not actually ruled on, I believe, by the trial court.
That was not, I'm sorry, I didn't hear. That was not what?
That was not part of the trial court's order. Unless I missed it, I don't think the order addresses the unconscionability argument. The amended complaint really doesn't plead any facts to support a claim.
Well, I'm not saying, I'm not opining on whether it seems meritorious, given the allegations, if any, that would, or ultimate facts, if any, that were put in the complaint about it. But I'm asking whether that would go to the existence of a valid agreement that includes a appraisal provision.
I suppose it would if it was actually pursued and there was something to address. But again, it's listed as one of the requests and it wasn't pursued. I don't believe it was argued or asserted at the hearing. The complaint doesn't really plead any facts. And it's pretty well settled that there's nothing unconscionable about invoking appraisal on a windshield claim. And there are no facts here. There's no allegations of fraud or duress or a violation of a statute or a violation of a public policy. So there's really nothing for the court below or the court here to address on the unconscionability issue. It was.
Let me can I pause for a second, just to not dicker with what you said, but sort of clarify what you said. You said the trial court did not mention unconscionability in the in its order, but it did note that there were allegations in the complaint that directly challenged the enforceability of the invocation of its appraisal provision. And I took that to mean a reference to those declaratory judgment actions that went to the enforceability of the policy and therefore the appraisal provision.
Yeah, Your Honor, I think that's a separate issue, enforceability versus unconscionability. And respectfully, I don't think there was a challenge to enforceability of the appraisal provision. Examples I can think of are where they argue that there's some reason that the appraisal clause cannot be enforced because it conflicts with another section of the policy. I think the Marsuka case was one case where it was within a preferred contractor endorsement, and the plaintiff was arguing about that by compelling appraisal, it results in a summary judgment on their issues contesting the preferred contractor endorsement or the right to repair endorsement. But I don't believe there's any, what I would describe as a challenge to enforceability. And in Cannon Ranch, this court said the appraisal clause cannot be found to be unenforceable unless it violates statutory law or public policy as well. So I don't see a violation of statutory law or even an allegation or of public policy. I can get to the other arguments that they're mainly ripeness and compliance with the policy as far as the amount of payment. Maybe that's the closest that comes to enforceability. But I don't really see any of the arguments as, classically an enforceability argument. I think it's more an argument. The arguments are based on ripeness from the appellate.
Well, I agree with that. I'm just asking you about the one argument about that it was unconscionable.
Right. Well, there's nothing there to support it. No facts alleged. So I just don't think the trial court has anything to rule on, and I don't think it's enough to affirm the order on that basis when we have a standard appraisal clause and there's absolutely, no facts to support even an allegation of unconscionability.
Let's say that one or two or three of the panel members of on this appeal, we judges thought that it was something that needed to be determined by the trial court before enforcing an appraisal provision. We're here on the interlocutory appeal by rule, right? And typically you can't hear matters for which there's no non-final appeal authority or jurisdiction. But is there an argument that it would be necessary to assess the denial of the motion to dismiss that declaratory judgment theory or count in order to determine the matter for which we do have interlocutory jurisdiction, which is the denial of the motion to compel appraisal?
I don't believe your Honor needs to address the motion to.
You're sorry to interrupt you, but you're talking about you kind of hinted at the merits of the unconscionable theory. There's no facts or real substance to the argument why it's unconscionable. That would be a determination on the merits of the motion, the denial of the motion to dismiss that claim. If it would we be able to do that if it was necessary to do that in order to reach the issue for which we have interlocutory appellate jurisdiction, which is the issue of whether the denial of the motion to compel arbitration was proper?
I don't think Your Honor needs to address it. I think the court may not have jurisdiction to consider the ruling in the motion to dismiss. So the court would only be considering the motion to stay or abate to compel appraisal. And if it wasn't ruled on by the trial court, there's some reason that there's some facts alleged or asserted that would provide grounds for affirming the trial court's order on an alternative basis based on unconscionability, then maybe I think this court would consider it. But I don't believe just putting the word unconscionability among the list of 10 allegations, declaratory allegations in the complaint, is enough where it would need to be sent back down just for the trial court to address that issue. It's really a non-issue, not supported by any facts or allegations.
And the court determined that you were not entitled to an appraisal at this time for other reasons, correct? Not based on court didn't need to get to that issue in order to decide that you were not entitled to an appraisal at this point.
Correct, Your Honor. And the court, they both, they denied everything. They did not just stay the breach of contract. They opened up the door to litigating the breach of contract. All requests for declaratory relief. Among other mistakes, one issue was same day was contesting whether appraisal was actually invoked pre-suit, whether they received the letter. The court stated that as a basis for denying appraisal, but that's wrong because appraisal can be invoked for the first time in litigation. So it doesn't matter whether they claim that they actually received an appraisal letter pre-suit. And First Acceptance did nothing to waive the right to appraisal in suit. And that takes care of issues 3 and 9 on their 10 item list in their request for declaratory relief. And the Florida Supreme Court has said when there's a dispute over the amount of the loss, it's for the appraisers to arrive at the amount paid, not the trial court. And what the trial court has done is turned everything into litigation for the trial court rather than a matter to be resolved by the appraisers. And as I said, they seem to frame the ripeness issue in 2 different ways. One is sufficient notice of a dispute or exchange of information, which were items number 1 and 6 in their request for declaratory relief. And then the other issue was whether First Acceptance proved it complied with its policy before compelling appraisal. And specifically, they refer to the limit of liability provision. And under well-settled case law, the claim's ripe for appraisal when post-loss conditions are met. The insurer has the opportunity to investigate the claim, and there is a disagreement regarding the amount of the loss.
Can I ask you again? And I don't want to make it a hobby horse, but it's probably too late to avoid that. What do you think the trial court meant by enforceability then? Because the amended complaint also contains challenges targeting the enforceability of policy provisions. If it didn't mean that, if it wasn't referring to the, I mean, fine, it wasn't referring to the unconscionability argument. That's what you say. What was it? What did it mean? What did the trial court mean when it said enforceability was that issue?
I think that goes to the compliance issue. I think the court used the word comply or some form of compliance about 15 times in the
so when you don't comply with a contract, that makes the contract unenforceable?
That's all I can figure as far as what
that's all you can figure besides acknowledging that he might have been talking about the unconscionability argument? I
don't believe, again, I think enforceability and unconscionability are 2 separate issues.
Okay, so then what did the judge mean when he said there was an unenforceability challenge that was preventing his granting a motion to compel appraisal?
It goes to the argument that First Acceptance didn't comply with the policy, so they cannot enforce the appraisal provision. So it goes to their compliance argument. So it was in terms of ripeness, the argument was that they didn't comply with the limit of.
So compliance goes to ripeness and enforceability. So when he said ripeness and enforceability, that meant both of those. The fact that the argument was that First Acceptance hadn't complied with the policy was an argument both as to ripeness and enforceability?
I believe so. I think there's general ripeness as far as exchange of information. What's new on this case is they couch it in terms of ripeness, but it's compliance with the policy in terms of paying in accordance with the limit of liability provision. So their argument is that First Acceptance must prove that its payment complied with the limit of liability provision before they can enforce the appraisal provision, which writes the appraisal provision out of the policy because the whole purpose of appraisal is to avoid litigation over the amount of the loss. So this argument is a way of litigating the amount of the loss. They argue that First Acceptance must prove that your payment was somehow correct under the policy, under the limit of liability provision. But the limit of liability provision is just a limit, that the maximum amount that they would pay under the policy. And
Mr. Clancy, you are at your 5-minute mark, so proceed as you wish.
Okay. I'll just briefly state that the ruling on the compliance issue is just based on a couple of false premises. One, that there is some correct amount that must be determined under the policy. That's incorrect. This court has acknowledged that, I think, in the Herc case. Any errors in payment are to be resolved by the appraisers. And also, there's the false premise that the appraisers use the limit of liability provision when they determine the appraisal award amount. They determine the appraisal award without regard to any policy limits. As we discussed, as we gave an example, the Middleton case and other cases where courts have acknowledged it doesn't matter what policy limitations may apply or what the basis is according to the plaintiff on the disagreement. All that matters is that the insurance company paid less than the amount of the invoice, and that's enough to make the claim ripe for appraisal. So no further questions. I'll reserve the balance of my time.
Great, thank you. Mr. Caldevilla.
May it please the court. Good morning, Your Honors. I am Dave Caldevilla, and I represent the appellee same-day windshields in this appeal. Your Honors, I respectfully submit that the trial court did not abuse its discretion or otherwise commit any reversible error, and this court should therefore affirm. The amended complaint asserts claims for both breach of contract and declaratory relief. As has been discussed a little bit today, the declaratory relief claim pertains to the validity, enforcement, the proper interpretation, and the proper application of the appraisal provision that the insurance company is trying to invoke. The insurance company's motion argued that the declaratory relief claim should be dismissed for failure to state a cause of action. The trial court's order rejected that argument and ruled that it does state a cause of action. And compelling appraisal would prematurely adjudicate the issues raised in the declaratory claim.
Let me ask you this: what you said, enforceability. What are the enforceability arguments?
Well, I think there are a few, but I will say,
you agree with the appellant that all of this is about enforceability of the when you say a contract or a policy or a appraisal position is unenforceable, it could be unenforceable because the one party failed to perform.
Yes, I think that's
the
one
term
basis. I think the validity of the provision it could be another reason. I think failure to comply with post-loss obligations I think there are many reasons. And
so the judge could have meant when he said unripe and unenforceable, in characterizing arguments opposing appraisal, that both of those could have been, the trial could have been solely concerned with the actions of first acceptance, not the procedural or substantive unconscionability of the provision.
So I'm not sure I understand Your Honor's question, but the deck action has not been ruled upon yet. The trial court denied the motion to compel.
I know, but in the order, the trial court said there have been challenges to the ripeness and the enforceability of the appraisal provision.
Right, and the judge also found that they hadn't demonstrated ripeness. So he did decide that with respect to their motion to compel appraisal, but he has not ruled on the deck action, and it's not within this court's jurisdiction under Rule 9.13 to determine whether the declaratory relief action is sufficient or whether it states the cause of action or whether the insurance company could seek a more definite statement. None of those issues are before this court, and this court has no jurisdiction to decide them. The court does
So
have.
my word of the day is talisman. I used it in the last argument.
Yes.
One of my concerns is this. So anytime a party opposing appraisal wants to avoid appraisal, they can just put a talismanic term in their complaint that says the policy is unconscionable.
So Judge.
And then you could say, well, you gotta adjudicate that entire deck action before the other party gets its right to appraisal.
I don't
It
think
might be
it's
unconscionable. So and then on the interlocutory appeal, where we have jurisdiction to determine whether a motion to compel has been improvidently denied, motion to compel appraisal, are we not permitted to look at the bare bones complaint and say all you did was just say it's unconscionable with no ultimate facts, and therefore that shouldn't be a cause to oppose appraisal?
right.
There's nothing to adjudicate here.
All right. So Judge, it's not talismanic. Whether I state a legitimate cause of action or a sufficient cause of action for declaratory relief was up to the trial judge to decide. Whether he was looking at it as we're alleging magic words or talismanic, it's not before this court. I'm sorry that and whether you want to look at it by dragging it into the motion to compel appraisal, that is a question that this court cannot answer. This court must assume that it states a cause of action, or really, I mean, just can't even touch that issue. If you look at the Mendota case, that's one of the very first things that court did. They said, look, this case involves an order denying motion to dismiss, and we have no jurisdiction on that. We dismiss that portion of the appeal. Now,
even if, disregarding that for the moment, the circuit court denied the motion to compel in part based on the challenge to the rightness of the demand for arbitration, correct?
Yes, Your Honor.
And in doing so, the court was interpreting the contract and looking at the allegations of what had happened or not happened so far, and that which has nothing to do with the unconscionability or not of the arbitration appraisal provision, correct?
Right. The judge hasn't gotten to the unconscionability.
So if we conclude that the judge was correct on those bases, the fact that there's a declaratory judgment action that alleges unconscionability or enforceability of the appraisal provision is beside the point.
Yeah, I mean, I think you could go either. I think they're both dispositive issues. I think.
Yeah, what I'm saying is that both are dispositive. So if the one about ripeness is dispositive, doesn't make any the rest of it makes no difference to us.
I agree, Judge. But I do want to
on the ripeness issue. Then I think that's. Thank you, Judge, for getting us back on track. Off my hobby horse. On the ripeness issue,
first time that's ever happened.
I'm amenable to good direction. Thank you. No, but let's say that let's presume for the sake of analysis that the letters never reached the windshield shop. Why does that matter when the insurance company received an invoice, the insurance company didn't want to pay it, paid less than the invoiced amount, and then windshield shop sued? Doesn't that just indisputably establish that there is a dispute? And therefore
there's a dispute, but it's not an appraisable issue.
What's that now? Sorry about that. I talked over you.
Certainly there's a dispute, there's a lawsuit, but it's not over an issue that's within the scope of this appraisal provision.
What do you mean? It's the price, the dispute. Your client, one way of perceiving the circumstances is that your client indisputably established that there was a dispute about the amount by, instead of doing anything other than suing, it sued. It said, you know what? You breached the contract by paying us too little. how is it kind of be in dispute that there is a disagreement about the amount?
Well, may I explain?
Yes, sir.
Okay, thank you. So the policy says that the scope of the appraisal is the amount of loss. Okay, the Florida Supreme Court has said in the American Coastal versus San Marcos case, it says appraisal may be required only as to those disputes concerning which the parties have expressly agreed. And it says all other disputes are beyond the scope of appraisal and must be decided in court. In this case, the policy expressly limits the appraisal to the amount of a loss and does not authorize the panel to decide the limit of liability. Counsel, Mr. Clancy, just now explained that was one of the last things he said, that, you know, the appraisers can't consider the limitations of liability.
Doesn't that kind of make the I'm sorry to interrupt you, but doesn't that kind of make the appellant's point? I actually thought about your argument on that, and I thought, you know what? You're right. This is about the amount of loss.
Well,
so they get to appraise it. How much, you know, a tree fell on my roof. How much damage was it? Not what's the limit, what's, you know, what you know, limits of liability, but how much damage was caused to my roof? Well, how much does it cost to put a windshield in?
Let me explain. So these letters that they claim to have sent, which there's no proof that they sent, it doesn't say in there that we have a dispute over the amount of loss. It says we have a dispute. We paid the prevailing competitive price. And that's what if you want to dispute that, we want an appraisal over that. Counsel just said a minute ago that the appraisers cannot consider the limitation of liability, can't consider the prevailing competitive price. And in fact, that letter, had it been sent, would demonstrate that the insurance company breached the contract because the endorsement says that that's not the standard. The prevailing competitive price standard does not even apply in this case. This is not like a Geico case, Judge Atkinson. This is a different policy that says that in the endorsement, it says liability for windshield glass repair and replacement, completely different standard. Our limit for liability for repair or replacement of your windshield glass shall not exceed the price we pay to our preferred providers, okay? So they're saying we have a dispute over the prevailing competitive price, and we're saying, who cares? The policy calls for the amount of loss.
I'll tell you why I care.
Let me explain, please.
No.
The amount of loss.
No, you let me finish, please. You let me finish.
Yes, sir.
I'll tell you why it matters to me, why I do care, and I think is a flaw, and I'll let you go on after I give my little blurb here. But in this scenario, it's the same thing. It's a windshield. So whatever it costs to replace the windshield is the amount of loss. So go on. Thank you. Sorry.
Okay. So let me respectfully disagree with that argument. So the car in this case is a Lexus sedan, right? The amount of loss, which is the broadest possible injury to the insured, is the price to replace an OEM windshield on a Lexus sedan by a Lexus authorized service department. That would be the most that this insured could get if it's just a windshield crack. The insurance policy says we're not paying for an OEM windshield, and we're not paying for the Lexus service department to replace this windshield. We have a limitation on our liability, and it's not the amount of the loss. You know, I have an old Corvette, a 66 Corvette, and I have a special policy, insurance policy, that covers OEM parts. And I get to choose where I'm going to take that Corvette to get replaced. That's not the policy that this insurance company issued. On my Corvette, I get the amount of the loss. Not this insured. This insured was capped at a limit of liability, Judge Atkinson, and they get to pay for cheaper parts, non-OEM, and they get to pay for cheaper technicians. They get to use their preferred provider. Let me just give you another example. You know, we've all been behind rock haulers on the interstate. And when the rock hauler goes over a bump, rocks come out. And it hits your windshield. And it hits the hood of your car. And it hits the roof of your car. And all of a sudden, you got a bunch of dings and scratches. And that's one insurance claim. The amount of the loss then is more than just the windshield. It's an extent of the damages. That's another way of looking at it. But, you know, we are now in this state, we are under the supremacy of text doctrine, as we all know. And if you read the Florida Supreme Court's decision in the San Marcos Villas case, you know, they make it very clear that the amount of loss is talking about the full extent of damages. And they said that's what the appraisal provision is about, the amount of loss. All other issues, all of them, are up to the court. This insurance company is not disputing the amount of loss, and neither are we. We are not seeking to recover the amount of loss. We agree that we are capped at the limit of liability. And that they want to appraise a completely different issue, which counsel himself just told you that
So
the
let me ask you,
are not even allowed to consider. Yes, Judge.
So let me ask you. So what you're saying is potentially that this, at least under the circumstances of this case, the appraisal provision really was never going to become necessary at all.
In this case, right? It's
Right.
beyond
So you're saying that because this person presumably is out so much more than what the limit of liability, you know, the actual amount of loss, he maybe had $1 million windshield, but you know, oh well, the amount of loss caps it at a certain amount. So we never need an appraisal provision in a circumstance like this. Is that right?
Right. Not in this case, Judge, because the appraisers are not even allowed to determine what the limit of liability. They're not allowed to interpret the contract. They come up with a number that has no bearing in this lawsuit. We are not seeking the amount of loss. They're not wanting to pay the amount of loss. That is the amount of loss is not a relevant issue in this lawsuit.
Now, what if the amount of loss is, so the only time the appraisal provision would be necessary, so you know, relevant, invocable, is if the amount of loss, the actual amount of loss, is less than the cap. But see, but that I come up with a philosophical difficulty there. So you're saying, well, it would be relevant if the amount of loss was a really cheap windshield, but the limit of liability allowed, you know, the insurance company allowed the insured to get paid for even better windshield. Therefore, the cheap windshield, which is all he's out, this crappy old windshield he had, but now the limit of liability gives him a better windshield. So then we get to go to appraisal, right? To find out what this cheaper windshield that was cracked was worth. I'm trying to follow your argument philosophically.
Well, I apologize. I'm having trouble following your question, but what my argument is that in Florida, the supremacy of the text is what we are required to follow. And my client did not draft this insurance policy. The insurance company drafted it. And in their policy, they make a big difference between the amount of loss and their limit of liability. They say this appraisal provision is set up only to decide the amount of loss. And I'm saying in this case, the amount of loss is not an issue. No one is raising the amount of loss.
But doesn't Mr. Caldavia, doesn't amount of loss necessarily include both the extent of covered damage and the monetary amount necessary to repair or replace the damaged property?
It includes it in the sense that it's a bigger number. It does not include it as a component.
But not always a bigger number.
Right. I guess it
correct. And so that's the point. I mean, what you're saying is under the circumstances of this case, based on what everyone agrees to be true, the amount of loss exceeds the limit of liability. And so there's no reason to have an appraisal because the appraisal can't be done in light of the limit of liability. It can only be done in terms of the with regard to the amount of loss.
I guess very similar to that, Judge Northcutt. I don't disagree, but I think my argument is more that it's just an apples and oranges situation, or maybe oranges and tangerines. But I don't think they're the same issues. But let me get to the point that you raised, Judge Northcutt, and that is that there are other reasons why the judge denied this motion. And the biggest issue is that they failed to prove that they complied with their post-loss obligations and that the appraisal demands were otherwise right. One party's attempt to evoke the appraisal provision does not automatically make a dispute ripe for appraisal. For an appraisal demand to be ripe, the party seeking the appraisal must comply with all post-loss obligations before the right to appraisal can be invoked. the duty to comply with the post-loss obligations applies to both parties, including the insurance company. In this case, the insurance company did not prove that they sent the 2 letters allegedly invoking appraisals, that they were actually sent, and there was no meaningful exchange of information to establish a genuine disagreement.
What was the other meaning? Sorry, Judge, go ahead.
What more was necessary? You submitted, this is the bill, and they said, we're not paying all of it. So what more?
Okay, what more would be the basis for their payment? The statutes and their own letters say, hey, we're enclosing these quotes that we used to come up with this estimate or with this payment that we made.
So you want to go behind that? You want to determine what were submitted in good faith, right? You want good faith? No,
we're not raising good faith like
but you're also challenging the appraiser, right? I mean, and you were complaining in your brief, you talk about the insurance company lowballing you.
Right.
You know, that it could encourage insurance companies to lowball and get this through the appraisal process as opposed to, you know, go in the court. So isn't the underlying premise of many of your arguments that you want a determination that the insurance company is acting in good faith before you ever even get to the appraisal?
No, ma'am. We have not raised good faith. This is not a bad faith lawsuit. This is a breach.
Not in those terms, but.
What's that?
But aren't those basically the arguments?
No, Judge. This is not the argument. This is not a bad faith case. That's a completely different cause of action. We're not raising whether they did things in good faith. We're saying they didn't do what they're required to do. The Florida statutes, and they recognize that. The section 626 9743 says every insurer shall, if partial losses are settled on the basis of a written estimate, supply the insured with a copy of that estimate upon which the settlement's based.
You're saying that's a post-loss obligation incorporated into the contract? Is that what you're saying?
Absolutely, and they recognize it because their own letter, which they haven't proved they sent, but their own letter says we're enclosing the quotes that we relied upon. But where are those quotes? They're not even in the record. They haven't proved that they sent the letter. They haven't proved that they sent the quotes, and they don't even put the quotes in the record. That is absolutely the insurance company's post-loss obligation. Just like an explanation of benefits is a post-loss obligation, which they have not provided. So yes, they definitely have to, just like an insured, if an insured is invoking the appraisal provision, the court is going to look and say, insured, have you complied with all your post-loss obligations? Have you provided the insurance company the information that they're looking for, that they're requesting? Yes, the insured has to do it, and so does the insurance company. And in this case, they did not prove that they did it. That is a factual issue. It's up to the trial court to make those types of factual determinations. And can
I ask you to interrupt? Sorry about that.
Yeah, and then you're gonna have to, and then you're gonna, and then, excuse me, Judge Atkinson. Then you're gonna have to stop because we have helped Mr. Caldavia use his time.
Okay, real quick. I follow your argument about 9743. I just wanted to, and we're also dealing with case law here. You know, I guess. Forget the name of the coastal something or other, but you know, you have a case in which that the partial loss and the requirement for an estimate was considered a post-loss obligation that, because it wasn't fulfilled, prevented appraisal.
Just this one, Judge. I don't have there's no published appellate decision.
You're saying the one we're about to issue. Okay, no, I just want to know. That's my quick question. That's okay.
I'm just using the standards of law that are published in the case law. I don't have a case that I can cite you that's our same situation. But
I don't think that's fatal to your argument. I just was wondering. That's all. I don't want to take any more time.
And so,
all right. So you need to wind up, Mr. Caldavia.
I'm winding up, Judge Northcutt. Thank you. For these reasons and all the reasons in my answer brief, we request that you either affirm, or if for some reason you reverse, then this case should be stayed during any appraisal process, because the court does not have jurisdiction to reverse on the issue of dismissal. Thank you so much.
Thank you so much. Okay, Mr. Clancy.
Right.
I have you at 4 minutes left.
Okay. Thank you, Your Honor. Right. The letters referred to are really not at issue here because they say that they never received them pre-suit. So what's before the court is the motion to compel appraisal in litigation. And that motion asks for appraisal according to the policy with the standard appraisal provision. And as far as what was meant by unenforceable, we've heard from Appellee's counsel what they meant by unenforceable. It was that they think they can litigate the limit of loss provision, which is essentially litigating the amount of loss before first acceptance can appraise the claim. But when appraisal is invoked, the limit of liability provision is taken off the table. It's not at issue by the appraisers. They don't consider limitations within the policy. They just determine the amount of the loss. So the issue is not even ripe for declaratory relief until after appraisal is completed. If then first acceptance reduces the appraisal award by the limit of liability provision, they don't pay the appraisal award, they limit it, then there would be a ripe issue to litigate the limit of liability provision. As it is now, there's no purpose served by that, and it eviscerates the appraisal clause because it allows them to litigate the amount of the loss and litigate a provision that's not even considered by the appraisers. So the reasoning from the opposing side is backwards on litigating the limit of loss provision. It's not ripe until appraisals completed. And also the opposing side does not cite a single case where an appellate court has allowed a party to litigate a limit of liability provision or litigate any post-loss obligations of the insurance company before the insurance company can invoke appraisal. As we discussed in our initial brief, every single case they rely upon, it's the compliance of the insured, not the insurance company. The order on—
But aren't those obligations both ways? I mean, how can you say the insured has to comply with post-loss obligations and you disregard the obligation of the insurer?
The only obligation that's been recognized on behalf of the insurer is to pay the invoice. There was one.
Well, in order to have appraisal, you have to have a disagreement, correct, over the amount of the loss, and that has to be done. It's just not just that this is how much we'll pay. The parties have to engage in a communication about what is the amount of loss, correct?
Respectfully, no, Your Honor. According to the second DCA case, the Hurt case, they don't have to engage in good faith negotiations. The court there said once—
I didn't say good faith.
They don't. According to that case, what the record clearly demonstrated a disagreement over the value of the claim, and what was on the record was an invoice and a payment less than the invoice amount. That's what we have here. That's what was in the Hurt case. That was what was in the NCI case from the 5th DCA, where the argument was there was an insufficient exchange of information. There, the 5th DCA also acknowledged all you needed was a payment less than the invoice amount. You don't need to explain, discuss, debate. Nothing more is needed before a compelling appraisal. And that was binding case law on the lower court at the time of this ruling. They don't need to do anything more than pay the less than the invoice amount. That's what establishes the dispute, and that's the record evidence that's undisputed by the other side. They dispute whether an appraisal letter was sent, fine, but in litigation, first acceptance invoked appraisal. There's evidence of a dispute, so it's an appraisable issue, and the claim's ripe for appraisal. And on the going back to the earlier discussion, as far as I still believe there's a difference between enforceability and unconscionability. Unconscionable is just a word that's used once in the amended complaint, but there is the Rabaya case from the second DCA from 162 Southern 3rd 348, where this court stressed the gatekeeping function in response to requests for declaratory relief. And the court said it should consider whether circumstances beyond the pleadings may signal that there's not a bona fide need for a declaratory relief, or it may become clear that the act is being used to foster frivolous or useless litigation. That's also the second DCA case, X Corp versus Y person.
Okay, Mr. Clancy, you're at the end of your time, so you need to wind up.
Thank you, Your Honors. We'd ask that the court reverse the trial court's order and remand with instructions to stay the case and compel appraisal of the claim.
Okay, thank you both very much. In order to leave our virtual courtroom, you need to click the icon in the lower right-hand corner of your Zoom screen.
Thank you, Your Honors. Have a great day.
You too, Mr. Calavia. Okay, that's our last case on this docket. And so with that, we are adjourned.